Right, we have our panelists here already who will take us through those stories. Of course, the biggest one being the tender row and the altercation that is going on between Jubilee and NASA over, of course, the relatives and of being involved in this particular case of the tender ballot row. We are joined this morning by Miguna Miguna, who is Nairobi governor candidate. Also, we have with us Senator Mutula Kilonzo, who's a senator from Makueni. We have also with us Joshua Kiptoo, who is a tutorial fellow at the University of Nairobi and also an advocate of the High Court, and Senator Kimani Wamatangi, who is a senator from Kiambu. You're eagerly waiting for Kimani Ichung'wah, a member of parliament from Kikuyu, to join us much later in the course of the program as well. Let's just begin with Miguna Miguna. Looking at the recent development, what will be your take so far? Everyone is saying, oh, I have a relative, of course, who's sitting or was sitting in the High Court bench, which made the ruling. And of course, Jubilee is saying also some members of NASA also, they have relatives within also the judiciary. Where are we headed?
Debarl, I don't think everyone is saying they have relatives at the High Court. I don't. And if I heard James Orengo carefully, he said he has relatives at the highest office in the land. And he was trying to explain that having a relative in the judiciary doesn't matter. Let me say this, it does matter. Judicial neutrality and impartiality is central to the administration of justice. So if in fact Justice Odonga is related to James Orengo,
yes,
and Mr. Orengo appeared before him for any case, he should have declared conflict. And he should have recused himself. That is just plainly wrong for any judge to preside over a case in which there is even a whiff of suspicion that there could be conflict. So number two, it was also incumbent on the Jubilee advocates to raise that conflict in court if in fact they were aware of it. If they became aware of it afterwards, it will become one of the issues that they will raise at appeal. And I believe that the appeal court would probably uphold their objection because it's not allowed. Number three, I think it is unfortunate that the executive is engaged in any kind of tussle with the judiciary in a public domain. It's not acceptable.
Yes.
But the president and the deputy president are now campaigning, and in their political campaigns, they are allowed to raise issues just like Kenyans, because he did not release the statement at State House or Harambee House, and therefore it did not bear the emblem of head of state or head of government. But he's still head of state and head of government. And whatever he says carries a lot of weight. And he should guard against appearing to be antagonizing one arm of government because of the power and prestige that he carries. And it is also a constitutional remit that the president has a constitutional duty to uphold, maintain, and try to encourage national unity. And appearing to antagonize the judiciary or careless statements in the public that might cause friction and disunity is unfortunate. So if I were advising the president, I would tell him to be very cautious and not to utter careless statements.
All right, let's hear from Senator Mutula Kilonzo. First of all, you think the president overplayed his hands?
Yes, I think the president and the deputy president are completely out of order, and we must say so. And the reason is because the attack was not only on the judiciary, but on the person of the Chief Justice. And if you recall, the president himself went to Kisii and attempted to take credit for the appointment of Justice Maraga as a Kisii. Let me just say this and begin with the court case. Count the number of senior lawyers who were seated in court when this matter was going on. Attorney General Githu Muigai, Waweru Gatonye, Fred Ngatia, The other gentleman who I can't remember his name, who appeared for the IEBC, Harrison Kinyanjui. These are very senior lawyers and of repute. Now, an application for recusal is made in court where you clearly state the grounds upon which you want the judge to recuse himself. It is not the first time that James Orengo, senior counsel, is appearing before Justice Odunga. This is called sour grapes. It's not the first time. It's not that Raphael Tuju or any person in Jubilee or Kipchumba Murkomen, for that matter, has now become aware of the relation between, if at all, between James Orengo and Justice Odunga. So, as far as I'm concerned, Debarl, I want to say that the attack on the judiciary is unfortunate, must be condemned, and is demeaning of the person of the president and the deputy president. These fellows, and I disagree with Miguna Miguna, that the two of them, even if they are campaigning, cannot behave like ordinary citizens. The president took oath to protect the Constitution. The deputy president took oath to protect the Constitution. The chief justice is the head of one arm of government. And therefore, if they have any protest, that protest should go through the Attorney General in a presentation in court. Because the statements they are making today, those statements cannot be used in a court of law. As we speak, even if you went to the Court of Appeal. Yes. The last point, which is even more important, the judgment was unanimous. Justice Odunga is one judge. It was a bench of 3 judges. So if assuming that you have an issue with Justice Odunga, there were 2 others. If everybody was to declare an interest, Justice Mativo come from Boni. So it means that I cannot appear before him. Some of these things don't even make logic or legal sense. What in the judgment don't they agree with? What portion of the judgment did they agree with? If we wanted to object, for example, to the Supreme Court, Justice Njoki Ndung'u was a PNU activist, a declared PNU activist in the presidential petition. Somebody would have come up and said, this lady is incompetent and should not sit in a presidential petition because she is known to have supported this, the one side and arm of government. So those are just excuses. But we cannot allow people to lose a matter in court, then attack the impartiality of the judiciary, particularly at this point. This is what took us to the 2007 chaos, and it is wrong. Debarl, it must be condemned. If a person of the character of Raphael Tuju, of senior lawyers like Kipchumba Murkomen and Professor Kithure Kindiki, must present their argument. There's nothing jurisprudential, and I want to tell Kipchumba Murkomen, there's nothing jurisprudential about attacking a court in a political platform. If you want to argue jurisprudence, you go and present your arguments in court. Those arguments are then recorded, and if the judge disagrees, you bow, you say most obliged, you file a notice of appeal. You don't go to Baringo and behave like a schoolboy, because that is schoolboyish.
So on the issue of neutrality, as Miguna puts it, then you think also there was a compromise there? No. As far if provided that there is no person, when you make an application for recusal, you say, we have an objection to you appearing. Because everybody is related to somebody. Somebody comes from somewhere. You don't have to make an application. No, you have to make an application. There are times when judges disclose that they have an interest in a matter. An interest. Yes. Means you have an interest in a matter, you have an interest in a client. You know the client personally, or you have dealt with the matter before, or you have made a ruling before that is related to the matter before you. You just don't say, I recuse myself because this fellow is my brother. I don't recuse myself unless somebody says, I have information. And that information is that in this ruling, you are going to be biased. Debarl have just said that is not the first time that Senator James Orengo has appeared before Justice Odunga. Yes. When did it become a matter of the fact that he's married to somebody else? Yes, you're bound to have a relative. You're bound to have a relative in the judiciary, in the Supreme Court. Thank you. The judge is bound to come from a region where you came from, or your village. All right. That is not a ground for recusal. Okay, let's hear from Joshua Kiptoo. No, not ground for recusal at all. Neutrality, compromise. What is your thoughts this morning?
I speak from 2 positions. One as a teacher of jurisprudence, at the same time officer of the court, there's something we always say when you practice. The moment you're admitted to the bar, or even a judge is sworn in, there's always that oath that they take. Even lawyers, you can imagine lawyers in private practice, when we take the oath and say that we accept to be officers of the court. Debarl, do you know the implication of that is that even when I'm presenting my client, I should remember that my allegiance and duty is to the court. That is number one. So that makes me a part of the process, and I should speak the truth. I should say what is right. Right? Now, if it comes to the judge, the bar even goes higher. It's extremely important. And when you talk about recusal, I beg to disagree completely with Honorable Miguna Miguna. When it comes to recusal, it is as clear as anything. I can, just from my limited practice, I can tell you when a judge recuses himself. One, possibly the judge formerly in private practice was even in a law firm that represented the same client. As far as that. Secondly, he or she was part of that company. He has done something for the company. If it is a political petition as it is, the judge can say, I've previously been a member of this party, or alternatively, I've represented IEBC in this matter before. It must be interest to the issue. It must be interest to the petitioner, not the lawyer, not the advocate. Those are two different people. An advocate represents a client. And he has said it so well. Jubilee had representation of top, I can tell you, first-tier lawyers. I don't think Fred Ngatia would let that go.
Never.
No one.
Never.
There is no single way. Even if you look at IEBC lawyers, there is no way they would let that go. Yes. On this one, Debarl, I can tell you, when it comes to the practice of judiciary, it's as clear as nothing. Secondly, I think from 2010 or from 2011, we've made tremendous steps that if there was one thing that we should always give Justice Mutunga, and you can never take it away from him, he empowered the judiciary. He made the judges be the real officers of court who can, in fact, anytime they give a judgment, you would always go back. And I can even pick out specifically that division, constitutional division. There's something different about that division. And even when we teach in school, that is the division we go for the judgment when it comes to the constitutional law. Those are the judges that every time you always go back and say the decision was refreshing. They always interpret. In fact, I can say that is the group that has given life the Constitution. And you can see the trail of judges who sat in that division before. They are impeccable, and their credentials speak for themselves. We can speak of Justice Majanja, we can speak of Justice Lenaola, you can speak of Justice Mumbi Mbugi, that even when it came to the usual rotational transfer, we as lawyers were complaining and say, how do you remove this person here? That tells you, you can't tell me lawyers across the board can just come up and say, this judge is good. If you just go out in the legal profession, because directly we deal with judges, if you go out and inquire about Justice Odunga, Debarl, I can challenge you, go to the Kenya law reports, pick out his judgment, and show me a whiff of bias. Anyone, in fact, leave alone this politics. Jubilee NASA has just come the other day. For information, NASA is just 2-3 months old. So you can't tell me all his life justice has just been about NASA. Maybe this one is extremely wrong.
Maybe this one will be the first one out of the gate for Judge Odunga.
To show you that Justice Odunga is alive to that allegation, I should take you back. Previously, Honorable Duale made it, in fact, call a press conference in Parliament and personally named Justice Odunga. What happened? If you look at this case, just to show you that the judge is cognizant, he is not just insulated from all these allegations. When this application was made before him 2 weeks ago, what did he do? The first thing, he declined to listen or to rule on the matter alone. He immediately applied to the Chief Justice and told the Chief Justice that the matter is of weighty public interest. For the sake of the timing and the perception, please constitute a 3-judge bench. That practice in the Commonwealth or even in any established judicial area is for the idea of, if you have 3, there's no single day you'll tell me that the 3 judges can collude. Look at even the composition. Justice Mativo has just come into the division and everyone is talking about it. So you would, even if you were to look at their judgments, you can see their jurisprudential differences. You can pick out from their judgment. So in picking the 3-judge bench, it was to answer into that queries and say, okay, let's assume Justice Odunga has always been favorable to the opposition. Let's assume that. Let's say that is true. He asked the CJ, appoint a 3-judge, and they sit 3. Professor Joel Ngugi, are we saying that he's incompetent? So are we saying that the judgment was only written by Odunga? That for me is a lie. And then, just to finish on the same, when it comes to separation of powers, Debarl, It is an established doctrine that goes back 3 centuries ago. It goes all the way back to the French Revolution. And when a nation state accepts to be guided by this fundamental principle of separation of justice, that is an important foundation of every country. Why do you, for example, I don't know if you go back to 2013, when there was a petition in Supreme Court against the win of Jubilee, but the moment the court declared that the election was valid and the president was duly elected, what changed immediately? The next thing was, even in the legal field, if you don't agree with the president, accept he's the president. There's nothing you can do. You have to call him His Excellency the President, because of the respect of the office, because of the respect of the institution. The same thing applies to CJ. The Chief Justice is a head of ANAM, and we can, in fact, we can just use evidence. For the last 5 years, if there's an institution that has really come up so well, is the judiciary. So why don't we just appreciate that basic? The legislature headed by the speakers, you can't touch, for example, you can accuse them, but the head still remains the head. So I think, just from a legal point of view, I don't think it was proper for the president, for example, to use such a platform and use such strong words against the division, because there's perception. A president is not just an individual, he's an institution. You know, whatever says carries the day. That's why when he makes our statements, it becomes headline, because this is the president. He is the president of the Republic of Kenya. These are 45 million people who look upon him. I would rather the Jubilee side to use the likes of Murkomen as they are. Let them talk, let them speak. They are politicians. You can give them the benefit of the doubt and say, okay, fine. It's a political season. It is the silly season. They can say whatever they say. In a political forum, let them proceed. But the president, in fact, out of the respect, he should just say that he calls for peace. He's whatever he respects the constitution, and according to him, as long as every system runs, he's okay. But coming out and attacking personally, that is different.
All right, let's hear from Honorable Kimani Wamatangi. Of course, you've been following what has been happening, and of course, the altercation here and there. What will be your comment this morning? You think the president was above board?
Well, Debarl, good morning. Let me start from this point. First, it is good that we set the record straight. Let's begin by what you've asked, because the broader question is the judiciary, or has the judiciary acted in a way that they are fronting a political mission? That's the bigger question. And if you ask me that question, because that's what you should answer, I would give you examples. Can we all remember that in the case of the Italian Prime Minister, Silvio Berlusconi, the judiciary in Italy made a decision that they were going to use all manner and means in the judiciary to see the Prime Minister ousted out of office. And indeed, finally, they succeeded not only to have Berlusconi out of office, but also to have him jailed, because they were fronting a political mission. So does it happen in judiciaries? The answer is yes. Now, coming to our local case here, you ask yourself, and there are many issues that have been raised by my colleagues here that you can pick clearly. Let me start from where, for example, Wakili here has stopped it. He says that when this matter was brought before Odunga, he refused to listen to the matter alone. Reason? Because he had heard this matter before. This matter had been determined before him. It was determined in the opposite, because remember, this case was filed before the printing, the ballot printing case. At that time, he made a judgment himself, and he stopped the tender. After stopping the tender, this matter was appealed by IEBC. After that, IEBC cited reasons which are allowed in the Public Procurement and Disposal Act, that a procuring entity can use certain facts and reasons to continue with procurement, e.g. urgency of a situation. And for the urgency of the situation, now that we have had to have the elections on that date, IEBC chose to proceed with awarding the tender, and that was accepted by court. Remember, this matter was brought back now to court by another presidential candidate after NASA had lost it. And so it found its way again back to Odunga. And why I would agree with what absolutely Miguna was saying is, ask yourself then, if justice, and I have a lot of respect for the judiciary, just like the president said, we have to respect the judiciary. But Debarl, the judiciary does not operate in a vacuum. It does not either operate for its own interest. The judiciary operates within public space and for public interest. This is a matter of huge public interest. This is not an issue that is lost to even the judges as they sit. They know we are presiding over a matter that has got huge ramifications, huge consequences. Now, so at the point at which the judge, with all due respect, decides that this matter has been before me, I've determined it before, it went the other way, so my opinion on this matter is already known. At this point is when he decides that I do not want them to hear this matter alone, I want to call other people. Now, is the judiciary short of judges who would constitute of that panel, and would it be at that point that that judge, in the interest of fairness and justice, no matter how scholarly or legalese we use, but isn't that at that point that one would say, okay, fine, constitute another bench and let me at this time recuse myself and let them hear it, because I did before. Now, secondly, if you ask me, if the president, as the president of the Republic of Kenya, and the deputy president, being also members of the Kenyan public, see that this is what is happening, now tell me, what stops them from, and you see how the president started his statement. Yes, we have a lot of respect for the judiciary. And so this is what's happening. Thirdly, Wakili here said, it was Senator Kilonzo who said that how many times, is it the first time that Orengo is appearing before Justice Odunga? And he said correctly, the answer is no. What you would want to ask yourself, and probably what the good judge would be asking himself, is, isn't it becoming a little too obvious that every time when Orengo appears before me with a matter pertaining to NASA or concerning NASA, there is already and always a predictable outcome? Because remember, as he has said, when Duale, Honorable Duale, was citing Justice Odunga, it was on this same matter, and on other matters, and every time, and this is what would concern me also as a member of public, that one, there is a coincidence of sorts, that every time when a matter pertaining to NASA or in the interest of the elections as far as NASA is concerned, goes to court, finds its way on his desk, and all the time the outcome is predictable.
All right, so from your point of view,
let me finalize.
Okay,
Let me finalize. On the question of naming the people who are relatives of this particular judicial officers, wouldn't the right thing be, you see, Orengo as a lawyer cannot start drawing comparisons, and that is why what he's saying would rubbish everything else any other lawyer would say. If you try to justify that yes, he has relatives, and so I would say have relatives, they have places, that's not the way to go.
Let's say from Miguna, we'll come to you.
For the judge to say, Debarl, let me finish. The way to go would have been for the judge to say and declare that these are not my relatives. If it was him saying, if he's saying that these are not my relatives, then that would be the case. But even before he declared, and what Miguna said was very correct, what every judge does, and we have been to courts also. We are not less, but we've been to courts.
Thank you, Wamatangi.
I have interest in this particular matter, so I will excuse myself.
Okay, all right. So was it injudicious? Was it also injudicious for?
Let me say this. Number one, I'm not in NASA, I'm not in Jubilee. I'm not saying anything because of any political affiliation. I'm speaking as a Kenyan, I'm speaking as an advocate of long standing. But let me refer you to the Constitution. My friend, Honorable Kilonzo Mutula, said that I said Uhuru is an ordinary Kenyan. I did not say that. And in fact, I cautioned the president for making careless statements. So I don't think he heard me. I never said that he can make any statement and that he's an ordinary Kenyan. But this is what the Constitution says. Chapter 10, the judiciary. which is Article 159A. It says judicial authority is derived from the people and vested in and shall be exercised by the courts and tribunals established by or under this constitution. A, justice shall be done to all irrespective of status. It does not matter whether President Uhuru Kenyatta is the president. It does not matter whether Honorable Mutula is a senator.
Yes.
Or my friend is a lawyer. Or Miguna is a gubernatorial candidate. It shouldn't matter when we speak about justice or anything. Justice is supposed to be blind. And when you go before the court is supposed to dispense justice. Now, it does not even matter whether you have a lawyer, whether the lawyers are senior counsel, whether the lawyers were called yesterday, whether you are represented by a maid, or whether you are knowledgeable in the law or not. The judge is supposed to dispense justice regardless, whether you raise the issue or you don't raise the issue. If there is a conflict, the judge is supposed to declare it, whether you raise it or not. Absolutely. This idea that you have to raise conflict for a judge to recuse, what if you don't know? Mm-hmm. What if you don't know? What if it has been concealed? It should not excuse a judge who knows that he has a personal relationship with an advocate or a party before him that would just expose the judge to very serious, severe repercussions, in the sense that people will no longer have confidence in the decision of the judge. Right. And no, let me continue, because they had quite a bit of time.
Yeah, we'll take a short break. We'll continue with you.
Let me just finish this. And I'm not speaking necessarily directly about Judge Odunga. Mm-hmm. Now, judiciary errs. They make mistakes. They are not above the law. They are not supreme. The only supremacy is to the Constitution, not to the judiciary, yes, not to the executive. The reason why there are appeals is because we know judges make mistakes. Otherwise, there would be no appeal. In the decision of the Supreme Court in 2013 of Raila Odinga versus the IBC, the petition, and Uhuru Kenyatta was a respondent, the judiciary made a decision on that petition. Did court accept it? No, they didn't. Did they criticize it? Yes, they did, rightly. They said, we respect the judiciary, we respect whatever decision has been made, but we disagree with it. And they went on public forum and attacked the judiciary, as they should have, if they were aggrieved and they felt that they could no longer raise it within the ambit of the judiciary. And they said all manner of things. So what I'm saying is this: what is good for the goose is good for the gander. You cannot say that President Uhuru Kenyatta cannot speak if he is unhappy with a decision made of the judiciary. What he cannot do,
threaten.
What he cannot do is threaten. What he cannot do is say, we are not cowards, implying that there is something else they can do. Yeah. But he can criticize. He's allowed, yes, a freedom of speech.
Okay. Allow us to take a short break right now. Before we took a short break, we were on you actually, Mutula Kilonzo. Yes.
I just wanted to make a comment on Article 75, so that...
Article 75.
Yes. A state officer shall behave, whether in public or in official life, in private life, or in association with other persons, in a manner that affords any conflict between personal interest, public and official duties. That refers to the president.
Yes.
And therefore, there's no point where the president becomes a Jubilee aspirant and therefore can make a comment and becomes a president when he comes back to State House. That's what I meant when I was referring to Honorable Miguna. The second thing is, Jubilee knows for a fact, and you cannot dismiss the argument, that Jubilee was represented by one of the best lawyers in town, including the Attorney General. Yes. The statement by the President and his deputy point to the fact that they have an incompetent person representing them in the name of the Attorney General. And I'm not afraid to say so. Number three, Debarl. The point is this, that since they have said, I don't know whether in fact Jubilee want to have raise an appeal. If they were to raise an appeal, the grounds they raise that Justice Odunga is related to James Orengo, that ground would not succeed in the Court of Appeal. That I can tell you for free. Mm-hmm. So what is the purpose of what they are doing? The purpose of what they are doing, and now to go back to Miguna, It's not that the fact that the president cannot make a comment. He is free to say whatever he feels like.
Yes.
The point of the matter is this, that as my good friend says here, my learned friend, is that there is a certain perceptions that comes with the office of the president. When the president makes comments about the judiciary and the chief justice so casually, as if he's seated somewhere eating nyama choma, it creates a perception and demeans the position of the office of the judges. That is where we should, that is what we should, we're not talking about a single case. This is a single case, but you're talking about an institution.
Right, but
minute you paint that picture, the minute you paint a picture that Justice Olunga or any Luo sitting in the constitutional division is related to James Orengo, is going to be to favor NASA because he's Luo. It's a wrong impression. Because,
let him finish.
Because Justice Professor Ngugi is Kikuyu, but that nobody is going to raise those issues. So therefore, you must at all points be able to make sure that you do not create a public perception that if I appear before a judge who comes from Kiambu, I will then tell him, because I fear that he might rule against me because I'm a NASA adherent, therefore recuse yourself. That is a problem about attacking judges in the manner they are doing. You can attack a judgment and say, paragraph 14, which talks about public participation. We were not aware of this public participation. Where is it in the law that you find this?
But wasn't
then you point that public participation ratio, we call it ratio decidenza.
But the question which is being raised here is the fact that wasn't it injudicious of Judge Odunga to actually go full steam ahead with this particular, sitting, knowing full well that yes, he's also remotely connected. Yeah.
Well, it's not a question of remotely connected. The fact is that that issue was not before him or was not before the bench. That issue was even, that's what I'm saying. In terms of an issue, if that issue was to be raised on appeal by Jubilee or IABC, it will be dismissed on appeal. It will be dismissed on appeal. Because the question that, we have dealt with so many cases about bias.
All right.
Even in many inquiries, there is plethora of judgment. What is the real likelihood of bias? What would the common man on the street think about the fact that there were 3 judges sitting and one of them is alleged to be related to James Orengo? I mean, that argument is...
All right, okay, let's say from Joshua Kiptoo, then we come to...
A quick answer to that, Debarl. I just need to answer what Miguna Miguna says. He quoted COD in 2013, and I agree with him that COD went on the full force, hitting at Supreme Court. I think from their hard-hitting comments and everything, Supreme Court has almost never rediscovered itself since 2013 presidential debacle. They even took away the discussion where the rest of us in the academia were trying to dissect the judgment. The political implication almost buried the judiciary. That if you look at the 2-3 years following the decision, the Supreme Court was more or less lame duck, and you'd find lawyers more comfortable with just finishing their matters at the Court of Appeal. Now, that is one. So 2 wrongs don't make a right. In a way, the opposition damaged the Supreme Court after 2013. I wish, or I would prefer they would have respectfully discussed the content of the judgment, because they went full force on individual. I remember that time them bringing out the question of Njoki Ndung'u, saying that she was PNU, blah blah. So 2 wrongs don't make a right. That's number one.
But it's after the judgment.
Yes, after the judgment. Secondly, even if I'm to discuss the decision that was made by the 3-judge bench, funny enough, do you know NASA lost in that petition?
It's a fact.
Completely. All their submissions were completely dismissed. Who won? Jubilee won, because Jubilee answered against those particular submissions, because NASA's main concern was impartiality of Ghurair, saying the president and the proprietor of Ghurair have a relation, they have hosted him in State House. Those were their concern. So at the end of the day, the court dismissed entirely.
And the evidence.
Entirely, everything. In fact, they made it clear that what NASA was alluding to was more of innuendo, rumors. So in short, Jubilee versus NASA, if we are to reduce it to Jubilee versus NASA in that matter, Jubilee won. That's number one. Yes. Number two, the court only considered one thing. I'm saying Jubilee won because they were successful in having NASA's submissions completely dismissed. Then Ekuru won because whatever he brought to the table was on the issue of public participation, which is a principle that the rest of us in the legal field wish to understand. This is the first time a public procurement matter, like, in a way, it is a bit presidential that we would wish to understand how exactly does the court would want it interpreted. Then finally, if it comes to the issue of judiciary, when it comes to elections, this is what I noted. After the nominations, now that the parties failed to conduct nominations, starting with opposition, going to Jubilee, I wish you were in that political parties tribunal. There were so many cases. We would stay late into the night, up to 12, because of one thing. That tells you something. Failure of other institutions is being heaped on the judiciary. The parties failed to conduct nominations. Everyone was rushing to court. Number two, at this point, IBC is at question. Let us train our eyes on IBC. Simple things. Why is IBC fumbling over and over again? Are you aware that in this particular matter, previously, the court had ruled against that the same tender? If you would ask me, due to the timing we have, and you know, we have very two powerful competing forces. Jubilee is a force to reckon with. NASA is a juggernaut. You have to accept that. Why did IBC let it this like to go this way? After the court had pronounced itself previously, way back in March, why didn't they act? So I think it is high time for us to say IBC should step up in the sense that we need voters to decide, not the court. It should be the voters, the voters, nothing else.
All right, let's hear from Kimani Wamatangi. We'll come to
Yes,
Kimani Ichung'wah.
Debarl, I had expressed myself very clearly on this, but I just want to make three very quick points to affirm what I had said. One, and these officers of the court will tell you, as lawyers, that in 99% of all cases, if a judge has presided over a matter, expressed his opinion in a judgment in that matter, if that matter is reintroduced to that court and he is asked to preside over the same, in 99% of the cases, the judge will decline.
No,
They will say that my opinion has already been expressed in this matter before, and so let somebody else hear it. And it doesn't matter how much he says no. We have had matters that we have filed in court ourselves. And I'll tell you what. And if justice is going to be dispensed in that court, this is it. This is the fact. At the point, and this is the question you need to ask yourself: did the judge know that there was conflict of interest? And the answer is yes, he did. This is how he knew, and it is as simple as that. When the matter was filed, and he said, excuse me, I cannot listen to this matter alone. Bring in other people. Why did he do so? It is because he realized, excuse me, it is because he realized at that point that there is a conflict of interest if I listen to this matter alone. That is why I want you. That's why I want you to bring other two people. Otherwise,
But he said it.
You are riding on assumption.
No.
You are riding on assumption because they said it was yes.
This is my opinion.
It's a wrong opinion.
No. Yeah, my
Because
friend, listen.
you're misquoting the law.
No. Listen, my friend. When the judge says,
Let it finish.
when the judge says that I cannot listen to this matter alone, I want another two judges to listen to this matter with me. This is because he has realized that there would be, because of other expressions he has had on the same matter before.
But what discernible difference will it have made? Just a moment. Okay. No. Let's go sequentially. We also hear from Kimani Ichung'wah who's here. Just finish. Yeah.
Let me finish my point.
Okay. Just finish. Okay. Finish the point.
Let me finish my point.
30 seconds, sir.
Secondly, Debarl.
Just a moment.
Secondly, Debarl.
Let him finish. Okay. Order. Miguna Miguna and
you see,
okay.
you see, Debarl, and I want my friend Mutula to know that, you know, as I told them here before, this law and this constitution is not written for lawyers. It is written for common people.
But it's in English.
In this country, we are 45 million
All right, thank
people.
you. Thank you.
Probably only 100,000.
Let's give a chance to Kimani Ichung'wah. Okay, just finish up. You make it then.
I have a point to make, but I have to caution him because he's interfering with what I'm saying, so that his opinion can ride high. Now, my other point that I wanted to make.
No. Let's rest on that point. We'll come to it. Just hold on to it. Let's hear from Kimani Ichung'wah is here. Yeah, Kimani. Good morning. Thank you.
Thank you, Debarl, but I wish you had let him finish because, as you can clearly see, Mutula will not even give him a minute to express himself. Whether based on the constitution that you cannot listen to each other or the law, since he's a lawyer here, we are laymen. But I think Senator Wamatangi has a point that this constitution is not just made for lawyers, as much as it's in plain clear English, then it's easy for people to read and understand it. And your interpretation doesn't have to be the right interpretation because you're a lawyer. We can also read English. But let me say this. Since I can read English, let me say this. And better English, by the way. I did attend some of the best schools in this country. I like you. Away from that, I think the issue really is not even the relations. And one of the things Kipropa said is that Jubilee won. And I think it's insincere of you to say that Jubilee won, because Jubilee was not even a litigant in that matter. The AG was not in court representing Jubilee. For us, we have made it clear that we wanted the courts to decide. We have no interest in who prints ballot papers. What we have an interest in is what agenda we sell to the Kenyan people, and that's what we've been busy doing. And we left the court matters to IEBC because it's IEBC that had been taken to court. The IG was there on behalf of the state, not Jubilee. Therefore, it's wrong in the first place to say that Jubilee won or lost in this matter, because we were not party to that court petition. However, and not on behalf of Jubilee, as a Kenyan, as a MP-elect for Kikuyu,
the only MP-elect.
Yes, the only one, by the way. I will be seeking to be enjoined in the new case that.
Which new case?
The one you guys are filing. Not the appeal. Not the appeal.
Okay.
The new one.
The complementary
on
complementary voter.
Yes, on complementary voter identification. Because clearly these guys are not interested in having an election, and you want to use the courts. And our concern now as a political party is on the relations between Orengo, the judges that have been involved in these matters. Those judges, as Senator Wamatangi is saying, judges who have previously listened to cases related to these electoral matters and IBC issues. Yes. Justice Mativo, yes. Justice Odunga, Justice Guge. And let me say, it is also very wrong, Mutula, to even pretend that anybody has raised issues on Justice Odunga for being Luo. For heaven's sake, I all along thought he was Kisi. And I have never had a problem with Justice Odunga as because of his ethnic inclination. But I have a problem with Justice Odunga presiding over a matter where his own brother-in-law or whatever relation is a litigant. I have a problem with Justice Mativo presiding over a matter on issues that he has previously decided on. Two, it is quite clear, Mutula, and I know you will not admit it on national TV.
No, I can't.
But it is quite, it is rather obvious. That there was a moment Justice Odunga was on leave, and you wanted to file a case as NASA. You had to wait until Justice Odunga resumed from leave. Let me take it back. Now you have filed the case you have filed before Justice Mativo. This one on complementary voter identification. I will seek to be enjoined in that case. To be asking Justice Mativo, he should be able.
All right, let's hear from Miguna Miguna.
Let me say my final point very briefly on this issue.
It's a good thing. You should.
Let me. Okay, enough with the heckling. I know that's part of your strategy to distract people, like you are doing with Wamatangi. Unfortunately, I'm not easy to distract. My final point is on the question of justice. Whether I came late, I have a point to make. That Justice Mutula must not only be done, but it must be seen to have been done. Right, ask yourself, and that's a question Kenyans are asking themselves, has justice been seen to be done by these judges who are related? I hear Ouko is Ida Odinga's brother or brother-in-law. I don't know.
Okay, fine, thank you. Let's hear from... we need to close this. Thank you. We will come to you. You'll finalize your point. We'll come to you. Let's hear from Miguna. Please.
Order. Caution Mutula not to... Very orderly, and I will say this. My concern is this, and NASA should be listening to me on this one.
Yes.
They're being set up.
NASA is being set up.
NASA is being set up, and they are playing like chicken.
They're playing into their hands.
They are playing into the hands of Jubilee like chicken, and I'm worried because I thought these guys are strategists, and then I realized they're completely green on. What Jubilee is doing, and listen to me, the country should listen. What Jubilee is doing is making NASA be very excited about the wins that they are making at the Court of Appeal and at the High Court. And then after the election, the matter will not go to the High Court. The matter will not go to the Court of Appeal. It will go to the Supreme Court, and then if there is a dispute, they will lose. And then at that point, they cannot criticize the court. It's quite clear. But they are not being judicious in their criticism. They should be very interrogative of the court. They shouldn't take anything for granted. Just the same way in 2013, they were excited about IBC, they were excited about Oswago, they were excited about Hassan Isaac, and then I was even suspended because I criticized Isaac. And then after they lost in 2013, Isaac must go. What I'm saying is, Mr. Mutula,
Yes.
reduce your political excitement and exuberance and think like a lawyer and as a strategist. Yes.
Thank you. Let's say from
advice taken. I mean, it's very rare for Miguna to give free advice. Let me say. Let me
Probably a free note.
free note. Let me just explain. To explain the point of Kimani, Wamatangi, and Ichung'wah. The Constitution is very clear as to the composition of the judges, and it's in plain English. And I'm glad that Kimani Wamachungwa thinks he went to better schools than me. I mean, that any matter under 165.4 says any matter certified by the court as raising substantial question of law under 3, B, C, or D shall be heard by an even number of judges, not less than 3, assigned by the Chief Justice. That's what it says here. It's in plain English.
No, but
let him finish. Just let him finish. He's not even started.
Yes.
Yes.
The point, and I'm glad that Kimani Ichung'wah now that he's not opposed. He's going to join in the court on the complementary system, because up to now we don't have regulations on how the complementary system will be done. But I want to raise this point that we passed a law, and the law was that in these matters, IEBC, so that we go back to the point, would have public consultations on all these issues that they are dealing with, whether it's technology. But lastly, this is what Odunga did in 2013. When the and that is why NASA is in court. And I'm going to tell this to Kimani Ichung'wah, because in the procurement of this...
Ichung'wah, you make my name sound like
come on,
something
let
close
him
to
finish.
ODM.
Ichung'wah. Ichung'wah, yeah. My apologies. The court was aggrieved, and the court was not aggrieved, the court agreed with those people who were opposed to the procurement of the electronic system that was used in the 2013 election. But when it went to the High Court, this was what the court said, and I'll answer Senator Wamatangi, my good friend here, that the court was of the view that although the procurement was wrong, there was no time to start the procurement again. In 2013, what was the result? We had a disputed election. So this time round, and to answer Miguna here, the distinguished lawyer from the Canadian Bar Association, these issues will come up in the presidential petition if there's going to be one. And the question is going to be, did you raise this issue or not? Number 3, and lastly, which is even more important, is that the public must appreciate the process. If it's the question of the voter register, we passed a law that says that the recommendations of the audit team should be implemented within 21 days. Means if they are dead voters, they must be removed within 21 days. That has not happened. If it's the system that is going to be used, it must be tested 60 days before elections. So NASA is doing this country a favor by making sure that every process, whether it's of the ballots, whether it's of the presidential ballots, and remember we had a discrepancy of 2 million extra ballots, those issues will be tested later. But the question will be that, did you raise this issue before the elections? And that is the point where nobody is excited. And nobody is going to mislead us. And we are not misled by the victories in court. If it's a question of tallying, it's not like we didn't know that was the law. Okay. That was the law. We were just reminding Jubilee and the president, because he made a statement about the tallying of votes, that the law is clear under Article 138 as to where these announcements will be done.
Thank you. So we need to take just a quick round of your opinions or your statements. Then we'll have also caller hanging. There are callers who are hanging on the line. We'll take them also.
Debarl, my analysis still remains that the judiciary is taking so much in its hand because of the failure of others. At the moment, the court appears to be the avenue of settling issues that if the institutions were good enough or like they were functioning properly, they would have handled the same.
Yes.
Like the same administration action could have been handled within institutions without going to court. And I keep saying, if you look at how the judiciary for the last 4 years has turned out to be the arbiter, has turned out to be the avenue where we settle petty issues that the institutions could have handled. For example, when you talk about IEBC, why is it every of their processes always has a hitch? It's easy to pick out. Let me give an example. When IEBC said they're doing an audit of the voter register, and it was all out there, they were presenting KPMG. Everyone understands KPMG as a top audit firm. Fair enough. And you would think this firm has the ability to conduct the audit. And what is the idea of an audit? An audit is to weed out and to clear and present a report and says your statements of account. I'm happy and I would wish to congratulate Kimani Ichung'wah. He's the first MP, and him being from the same profession, he would understand. You would expect the audit would have finished these matters. So why are we again in court? Because of discrepancies. For example, if a simple thing like IBC launched an SMS platform, says that you can text the number in order to check your details. You text a 0 something comes back. That already questions. In fact, that already brings questions. Simple things like that. Why don't they do it right? In fact, it is out of their failure that you find them always on the defensive. To the extent that you find, again, they are unable to even defend themselves. Their communication strategy is not working. You would think Jubilee is their mouthpiece. Yet this is one of the competing major parties. So I would think the problem lies with the institution of IBC. I don't think they are ready. I don't think they are prepared. I don't think they are coming up and addressing the issues. That's why every time we have a matter in court, it's on IBC, and every time they keep losing. It's not because of bias. It is basically because of incompetence. So I think at the moment our focus and our discussion should be this: elections are here. Voters exercise this right once every 5 years. The stakes are so high. The only fair thing you can ask IBC is, please give us a fair chance. Let these guys sort it out once and for all. Let Jubilee, let NASA compete favorably. In fact, at the moment, Debarl, I would have expected the last 1 hour we would be discussing about the two coalitions, about their manifestos, about the campaign trail. Yeah. Are we seeing a promise? Are we seeing a change? Who is selling what? That should be the discussion. But you can imagine we are engaging in discussion of processes simply because of an institution that has failed. That for me is the main thing. And it's a very sad thing. Right. If we could only give voters a chance. And I think Miguna is right in one thing. NASA, in a way, is losing the perception battle, where I think the voter would be inclined to believe the Jubilee narrative that, look here, NASA is all about courts. They are not ready, because every time they're in court, I wish they would also up their game when it comes to campaigning and try work on that, because at the moment, I think even going to the election, the narrative by Jubilee is selling that, look here, we are ready, we are going to win. These guys are just wasting time in court.
They want to sabotage the elections. That
not even sabotage. Yeah. The new line is that they are cowards. They can't face us. And you know that says because the Kenyans will keep seeing them in court over and over again. Okay,
let's hear from Kimani Ichung'wah. Our callers are still hanging on the line. We shall pick them after you settle.
Kimani Wamatangi.
What did I say?
Kimani Ichung'wah.
Of course. All right. Kimani Wamatangi. Thank you very much.
Thank you. Thank you. And I think I would, as I start, I would want to ask Miguna to ensure that I'm not interfered with by Debarl. and Mutula Kilonzo. But anyway, I just wanted to answer Mutula Kilonzo. First, on the law that he cited, that yes, when a substantial matter of law is raised, a three-bench judge will be composed by the Chief Justice, but not necessarily so. And it is clear, because this is the same matter in content and character and detail that the same judge, Justice Odunga, listened to and determined himself. And on the first point that I raised, on the question of conflict of interest, the reason why a judge disqualifies himself from a matter he has determined himself is because he is not likely to come up with a different opinion on the same matter. And so, you know, so it is very clear. Now, secondly, you remember, the Chief Justice himself came to public when these matters were coming to court. And remember what the Chief Justice said. Before, he said that the courts are not going to make any judgments that will interfere with the election timelines. This was the declaration by the Chief Justice himself. So then here, a few days later, the Chief Justice, and I pity the Chief Justice and where the judiciary now, some of the officers are taking him, because see, like yesterday and the day before, he has had now to come to their defense and say and declare their independence when he himself had said in view of the timelines. And I'm sure when the Chief Justice was saying that, he said so in a recognition of the huge public interest there is in the matter of election and the election date. So here you have a judge who comes and says, because of public participation, and I'm glad that my colleagues here, Wakili here, and Mutula Kilonzo actually have admitted here themselves that it is the first time in the history of this country and in the courts of Kenya that you have had any row or dispute concerning a tender being adjudged on the question of public participation, because it has never been there before. In the law that we read in Parliament, I've been in Parliament for 5 years now. I'm a member of the Public Accounts Committee. I question this every day. The Public Procurement and Disposal Act is clear on when you require public participation. It is not about giving a tender. It is about other processes, about how you're going to have implementation of development plans and so on. But tell me, in law, how do you have this bench sitting here to decide how you're going to give a tender to Debarl? It is not possible. It is not there. And that is why, and the question you would be asking yourself is this. When the judges made the decision, let the printing of ballots for the other positions continue and the presidential be deferred, did they then specifically say that there was public participation in the process of these ballots and not in the presidential? I mean, those are the questions that abound, you know, and they would require an answer. And that is why, if you ask me, and I want to repeat my point, this law, as written for us 45 million Kenyans, was only intended to be channeled through this gentleman to help us interpret it when possible. But they must understand that part of what the requirement of this constitution is it has to be written in simple, plain English that can be understood by Mama Boga. And so they should cease this business of trying to introduce the scholarly language, legalese, so that they confuse the main thing, and that is the dispensation of justice.
Thank you.
On this matter, I'm very clear that
excuse me.
What should happen, what should have happened is the judge should have simply disqualified himself, and they should have let this matter be heard by a fair court, and at the end of the day, take into account what the Chief Justice himself said on the election timeline.
Thank you very much. We have callers who are hanging on the line. We shall come to you, Kimani, Ichung'wah, momentarily. Let's hear from our callers this morning. Hello, good morning. Good morning, Karanja.
Morning to you.
Morning. You have a question or a contribution for our panelists this morning, very briefly?
I have two brief contributions. One of them is that we should have a country after 8th of August 2017.
Yes.
Already the war drums are being beaten, and it's very worrying. You hear talk on the street of that this guy must win. If he doesn't win, then we're going to have war. I think it's very worrying, and also the security agencies should be very, very alert, especially in Nairobi. You know, the lower end of Nairobi. I think there will definitely be violence after 8th of August. If a certain candidate does not win, I don't want to name the candidate on TV. The other thing concerning our topic today is Justice Odunga. It's so obvious. NASA have found, when we were fighting for multipartyism, Kina Jimmy Orengo and Koigi Wamere would fear to go before certain judges. Today, Orengo have found a judge to who they take their cases to. That judge is called Justice Odunga. In fact, the joke on social media is that anytime there is a case, we always post the judgment at 8 a.m. on the morning of the judgment that we say Justice Odunga has ruled this way. And by 11, Justice Odunga rules that exactly that way. 99% of the time, Justice Odunga has given a favorable ruling in favor of NASA, called ODM.
Thank you.
That also, it is not, in the eyes of a common Mwananchi, justice is not done.
Thank you very much, Karanja. We have Caleb. Good morning, Caleb.
Good morning, Mr. Debarl.
Good morning. You have a question or contribution very briefly, sir?
I have a question and a contribution.
Let's take the question, please.
Yeah, number one, I want to ask the whole panel.
Yes.
Are they aware that one of the contentious issues that was brought before the judges was about the tendering process? And in fact, it is in the public domain that this tender issue, the chicken gate, has brought some people abroad there to jail, while it has not happened in Kenya. Why can't we correct this situation before we go to election? Mm-hmm. That is my number one question. Yes. Everybody in the public domain, we know that without a good tendering process, then the playing field is not going to be leveled. What is so much funny in Mr. Chebukati allowing the tender process to be so open and agreeable by both the contesting parties? Remember, even the Third Way Alliance is not comfortable. It's only one side which is comfortable with the tendering process. Surely, we want a united Kenya after this general election.
All right, thank you.
Number two.
Number two, can you just wind up on it very briefly, sir?
Yeah, so I want to say this, Mr. Debarl. When you are bringing an issue of such importance, yes, please try to pick on people of substance who can actually, when you are taking our time to watch the national TV, we can have something to take home. Remember, we had people like the late Professor Ali Makrui who could.
All right, thank you.
Be in the,
thank you very much.
Debate.
Thank you very much. We have Usha also standing by with you. Usha, let's hear what people are saying on Twitter.
Right, your tweets are rushing in, and of course I am happy to sample them. AM Live NTV, that is how you can get your comment through if you haven't done that already. So we start with Alex, who says, Uhuru will be declared the winner. NASA will move to court, but this round the courts won't favor them. It's a trap, which is sort of what Miguna had hinted at, I think, as well. We also have Francis, who says, if NASA is not prepared, they should just tell us, please. We also have Kimani, who says, Uhuru Kenyatta is wrong in attacking the CJ. We're a country ruled by law and the Constitution, not by personalities. We also have Njuhiga, who says, we have Humphrey, who says, why, when Jubilee loses, is it all unfair, but when any other side loses, it's always respect the ruling of the court. We have Alfred, who says, ask Jubilee guys if they'll be comfortable if the Ghurair case was referred to ICC, where Orengo James has no relative. And finally, we have Maimi, who says, we can't excuse President Uhuru Kenyatta for clutching on straws as he's drowning. What hope has he got other than throwing tantrums? So as you can see, a sample of mixed reactions. Some people seem to think that the president is acting wrongly, and then there are those who feel that indeed the IEBC seems to be favoring one side. But remember, AM Live NTV, that is how you can get your comment through. That is on Facebook, on Twitter, and on Instagram, Debarl.
All right, thank you, Usha. Also, Usha, there is Ido Hussein, and he's saying that IEBC is a cause of the problems. How can they keep insisting on Ghurair 3 times after being faulted? That is a tweet. Maybe we can pick it. Yeah, there you go. Right? 3 times being faulted as well. I think that is a very ticklish issue as well. Many thanks, Usha. Let's just hear from Kimani Ichung'wah as we're winding up.
I think we should go to another issue.
we're winding up on it, but there's a clarification that we need. You wanted to say something. It's only fair that we give him
something on the
not you, Kimani. Yeah, let's just wind up on this, but we look also on this issue of ambiguity when it comes to public participation, because yes, you move to court with the public participation, but people don't seem to understand what the public participation is all about. Just wind up on it.
I think actually it's good, because I actually wanted to comment on the public participation aspect in matters procurement, and I think what guides us on public procurement in government is Article 227 of the Constitution, and it's quite clear that when a state organ or any other public entity contracts for goods or services, it shall do so in accordance with a system that is fair, equitable, transparent, competitive, and cost-effective. And I think if those were the issues that were before court, on the question of procurement, then decision would have been made based on that. What NASA did, they went to court, and Kiptoo was right that NASA lost in all the plaints, all their submissions before court, because they went on very flimsy things. I don't know, Ghurair was related to who, they were friends with Uhuru Kenyatta, they had visited State House, and they lost on all those plaints. And the person who won, I agree with Miguna, is the independent presidential candidate, Ekuru.
Third Way Alliance.
Yeah, the Third Way Alliance. Miguna must be very happy with that one. being an independent candidate.
Third Way Alliance is not independent.
But, that is a guy who won. But the problem, and I think that's the problem Chebukati has also raised, under the purview of the Public Procurement Act, because Article 227, the second clause, after that talks about a framework and an act of parliament, and that is the Public Procurement and Disposal Act. Under that act, there isn't any provision whatsoever to do with public participation. And why I would fault the judgment before the court and on the premise of public participation, and at least those of us who are legislators here, Mutula and Kimani Wamatangi, will tell you, in legislative matters, there is a framework under which we can engage the public in public participation on legislative matters. But when it comes to public procurement matters, there isn't anything that is provided for either within the Act or any other regulations. And therefore, when a judge pronounces himself on the question of public procurement, and interestingly does that on a procurement process that was not for presidential ballot papers alone. The procurement process was for ballot papers by IEBC, right from the ballot paper of the MCA all the way to that of the president. And then the judges pronounce themselves and say, then you can go ahead, irrespective of whether there was public participation on the ballot of the MCA, the member of parliament, the member of the county assembly, your own seat senator, and that of governors like Miguna, that those then you can go ahead without public participation. I'm struggling as a layman then to get to see where does equity then come in. Then you set aside one ballot paper, that of the presidency, on that basis of public participation.
Thank you.
Let me say this outside now the argument in contra. This is my own opinion and the things I've had out there. And what you hear out there, we say where there is smoke, there is fire. There is talk already in town that what NASA and the judiciary intends to do is to postpone the presidential election. Indeed, they are looking for a way how they can stop the presidential election from being conducted on the 8th of August. Principally because those who are related to certain judges in court are not prepared for an election.
Who? Talk in town is who?
No, Talking town. Let me say talking town. It's rumors, true.
Yeah, so
but rumors also do have some element of truth.
We cannot base our discussion on innuendos.
Let me say this. Talking town. I could even be the genesis of that rumor, maybe. But it's there on social media.
Don't bring it here.
It's there on social media.
It doesn't help.
No. Sources.
Let's stop it there.
You in the media. You in the media talk of sources. Can I also talk of sources?
Forget.
Credible sources, not social media.
Not social media.
Let's hear from Miguna. Just
Honorable Kimani was
Forget about
I say where there's smoke,
okay,
there's fire.
Let's leave it at that. Let's leave it at that.
It is actually my own opinion. Let me express it as my own opinion.
Thank you very much.
In my opinion, you are not prepared and you do not want an election.
Thank you. Let's hear from
Miguna. And you want to use the court.
Thank you.
Let me also finish by saying this because I don't want to say anything beyond that. That this election will be determined by the people on the ballot, not in the courts.
All right,
let the judiciary not subvert democracy by wanting to decide electoral matters in courts of law.
Thank you. Let's hear from Miguna.
Debarl, I want to say three things. Number one, I hope that we are going to say something about General Kaiseri. He was my friend, and he was a Kenyan. He's dead. I think we should honor him.
Yeah, we will.
Number two, I think it is quite interesting that I have heard some of my friends talk as if judges are above the law. Judges are not above the law. Judges are human beings like us, and they make mistakes. And it doesn't mean that if you have a right of appeal, you can't comment on a case. You can even lose the case at the Supreme Court and still be dissatisfied. You are still entitled to comment on it. So comment is good. Democracy, freedom of expression is good. Let us enjoy it. Now, the Constitution starts with a preamble which says, "We, the people of Kenya."
Yes.
Because this Constitution is not just a legal document. This is the only document that unites the country, that enshrines and entrenches the rights, and that should be supreme and is supreme. To the extent that any law is inconsistent with this Constitution, that law is null and void. Therefore, we didn't need an act of parliament to be able to assert, nor did the judiciary need an act of parliament to be able to assert the importance and centrality of the people in making important decisions. So, procuring ballot boxes and whether or not the procuring process satisfies the fortunate. I would want to believe that NASA does not want to move the date, and I would want to believe that NASA is exercising its rights just like any other person to go to court because they are entitled to it. I mean, they can go to court for any issue. Nobody is prevented from going to court, and it is up to the court to decide whether the litigation is frivolous or vexatious, and it's not up to us to decide. Nor does it mean that if NASA goes to court, others cannot criticize them going to court.
True.
So all I'm saying is that we have to be able to be aware that we want a united country, we want a peaceful election, and whatever discourse and discussions we have to be aware that Kenya must remain united.
Thank you. Thank you very much.
Yes. My comment is as follows.
Yeah,
Number
very
one.
briefly, we went up on this, then I'll give you opportunity to also offer your condolences for the Nkaiseri
Yes, so that I can answer to Senator Wamatangi.
Yes, I would like to.
The point is, Debarl, is that when the original tender was cancelled, IEBC then proceeded to say that they would rather have this company because this company has performed well in the past. So the portion where they missed is include a discretion. And my colleagues don't criticize the decision of IEBC because there's nowhere in the procurement law that says if somebody has done well previously, you circumvent the procurement procedures or procurement laws. That is where they went wrong. Number two, the incorporation of public participation and transparency and accountability is in Article 10. Senator Wamatangi here will confirm because he sat in one of the committees. We were unable to impeach Wambora because the court included something called public participation in impeachment of governors. So it's not new. It's something that is there. Lastly, nobody wants to move the date of election to 7 a.m. It's 6 a.m. on 8th of August, 2017. Let them rest easy. We all want elections on that day, and even I seated here on this table will criticize any person who wants to move that date because we must have consistency on election dates. Lastly, to say this, I'm not aware whether any person in court raised an issue about any other ballot other than the presidential ones. So it's not that the rest is because it was a non-issue before the court of law, and that is why they did not address it. But to say this, that when we sat in the select committee, we incorporated something called consultations. Everybody across the board. And this was brought about by the former ombudsman. His name is Dr. Atiende Amolo, because he said the previous commission refused to sit with them on election preparedness. We have said so. It doesn't harm to share information with the stakeholders, political parties. And I argued this with Raphael Tuju on sidebar. The fact that Tuju sat with the commission is not consultation. The fact that somebody from NASA sat with IEBC is not consultation under the law. They should consult everybody, multi-level, that the public is satisfied, because we're all interested parties. I'm an interested party. They should consult people who are not so political players, like my good friend.
A quick answer to that, Debarl, and I think this is what I'll try to put into context. And I picked an opinion by my senior colleague at the school, Mudomi Thiankolu, and he summed it up so well, where this issue of public participation or the whole thing came about, this matter. There are two things involved here. When IBC was procuring, they had an option of applying Section 91 of the Public Procurement and Asset Disposal Act, which allows for open tender. The same section provides for alternative, but the alternative is qualified. The alternative, for example, is direct procurement. Section 103 provides for the same. But for the direct tendering to happen, there must be qualification. One of them, that urgency, whenever an urgency or emergency arises. However, key qualification is that that may not be a preferred position if it can be seen that the process leading to the direct procurement has some questions about it. Whether, for example, the procuring entity deliberately chose to to delay and make agency a matter. Now, when you look at the matter when it came to the High Court the first time that Wamatangi is quoting, Muthoni has picked up so well and says the court annulled that particular tender award to Ghurair for two reasons. Number one is that the Secretariat had acted ultra vires. Why? There were no commissioners in office. Number two, the tender was inconsistent with the Elections Act because of simple thing. The tender did not provide for an integrated electoral system, which is a provision of the of the Election Act, which calls for an integrated system that has BVR, EVID, and ERT. Yeah. So they were told, for you to be able to award, please ensure these two matters are there. What did IBC do? They appealed again. Why are they appealing? To delay and to create time for the same direct procurement. They went back to the Court of Appeal. The Court of Appeal affirmed the decision of the High Court on 26th of April. Right. So look at the timing. On 26th of April, once the decision of the Court of Appeal was made, again, they went back, bought a bit of time, again directly procured with Ghurair. So that tells you, Debarl, the problem is not the politicians, the problem is IBC. Are they really consistent? Are they sure they want to do a credible election? Right. They should answer that.
All right. Kimani Wamatangi, of course, also you have to couple it with your condolences for the Nkaiseri family, because also we are strapped for time so that we can give each of this 30 seconds to also just offer their condolences.
I think I had made my opinion on this, but I want just to quickly answer what my colleague here says, because we've, one is that derived from the Constitution. What the Constitution has done is laid the principal guidelines as the top law, but then provided for enabling legislation to be made by Parliament. And in what Mutula or Kilonzo was citing, Article 10, there is enabling legislation to oversee those provisions, for example, in enactment of the Public Procurement and Disposal Act. And in that Public and Procurement and Disposal Act, what Wakil here is trying to quote, you're quoting it and mixing it. It is very clear, very, very clear. At the time when a procuring entity is allowed by law and the circumstances under which they can single source. And it cites the case of urgency. And I want to correct you on some of these things, Wakili, because we've been in the practice also in Parliament. For example, like when we had Al-Shabaab attacks, and a county government has got to go and procure and that is exactly the situation. Now here we have a timeline from February of the 8th of August. And so the procuring entity itself simply says that we are starved for time. It is an urgent matter. We have to procure.